Probably heard the phrase, if you cannot afford an attorney, one will be provided for you. It's a constitutional right guaranteed by the Sixth Amendment. Defendants who can't afford a lawyer are supposed to receive a public defender. But are there situations where a judge might deny one? Who decides if someone qualifies, and what criteria are used to make that determination? We verify. When someone is facing criminal charges, an attorney can make the difference between freedom and a lot of time in jail. The right to counsel is enshrined in the Constitution, but the process isn't as straightforward as you might think. Can a defendant be denied a public defender in Alabama? Let's verify. Our sources are the United States Supreme Court, the Code of Alabama, and legal research database Justia. Here's what we found. According to the 1963 Supreme Court case Gideon versus Wainwright, anyone facing felony charges is to receive a court-appointed attorney if they can't afford a lawyer on their own. Then in 1972, Argersinger versus Hamlin expanded that right to misdemeanor cases where jail time is possible. In Alabama versus Shelton in 2002, the court clarified that defendants charged with minor offenses that carry no risk of jail time, like certain traffic violations, are not entitled to a public defender. In Alabama, there are additional standards you must meet. Alabama Code Section 1512(1) states you must qualify as an indigent defendant to receive a public defender. That means your income must be at or below 125% of the federal poverty level. If your income is between 125 and 200%, that's double the poverty line. The judge must determine that paying for a lawyer would cause you substantial hardship in order to qualify. If you earn more than 200% of the poverty level, you could only qualify if you're charged with a felony and the court determines not providing counsel would cause substantial hardship. Under Section 1512(5), judges also consider your ability to pay for legal counsel based on your assets, disposable income, the nature of the offense, and the complexity of the case. And according to the 1975 Supreme Court case, Ferretta versus California, defendants have a constitutional right to represent themselves. If you choose to waive your right to counsel, the judge must ensure your decision is made knowingly and voluntarily. So we can verify that yes, a judge can deny you a public defender in Alabama. You can be denied if you don't meet the financial eligibility requirements, if the charge carries no risk of jail time, if you fail to provide required documentation, or if you choose to represent yourself. All right, if you have something you want us to verify, text us at 256-382-2692.